I'd like to welcome everyone to our first expert webinar. Today's webinar is on privacy, taught by my old friend Joe Saul. We've actually known each other since the first day of law school, I guess 27 years ago at this point.
Oh, I wish you hadn't really said that.
Oh, the law school or the 27 years? So law school is like boot camp, but they don't give you weapons because there'd be too many friendly fire accidents involving faculty. So bringing flashbacks, that's not fair on the morning. So I have wanted to have Joe teach classes on privacy and security for years, but Joe, because of his previous positions, was unable to. Just to recap, Joe was the chief privacy and chief security officer of what then was Thomson Reuters medical unit dealing with health records, went through a number of name changes and eventually became Truven. Truven was eventually purchased by IBM and became a part of its Watson group dealing with medical records. The reason why we actually are able to have Joe is I successfully pried Joe out to join one of the startups in our portfolio called Apamaya. And this is not a plug for Apamaya. I just want to disclose that he is part of one of our portfolio companies after a lot of very dedicated and tenacious lobbying and some blackmail photos from 27 years ago, which of course is what it takes sometimes to get people over the line in recruiting. So let's just leave it at that. Joe is one of the world's great experts on everything from HIPAA to GDPR, CCPA. Joe says I'm not allowed to tell you he's one of the top 10 privacy experts in the world, but I will say in my fantasy privacy league, he was a high first round draft choice. So on that note, let me welcome Joe and thank you all for joining us on a Wednesday morning. If you have questions, there are two ways to ask them. At the bottom of the Zoom screen, you have a chat feature, and there's also a question and answer feature. I slightly prefer the chat, but I do see both. I also will be checking my phone and email if you'd like to reach out that way. That's less preferable because I sometimes miss questions there for Joe. But anything you'd like to ask Joe, this is your chance. I have a number of questions myself, but feel free to chime in and let's see if we can learn something about privacy this morning. So I would ask if there's anything you'd like to correct in that intro, but I don't think I want to give you that chance because
fair enough.
So let's talk about privacy for a moment. So, we have general layperson conceptions of privacy, but I think where I'm most interested in is the legal conception of privacy. So if I don't know anything about data privacy laws, can you tell me just some of the things I should know about as a first-time CEO or an investor? And also tell me if there's any difference between whether that answer depends on whether I'm in Europe or California or elsewhere.
Wow, that's actually quite a lot. So let me try to chunk it out a bit. Privacy can basically be conceptualized as the right to be left alone or the right to control intrusion into your personal space. When you get into regulating it from a data privacy perspective, what it's really about is making sure you don't misuse information that you're allowed to have and that you only collect the information that you're allowed to have. And I want to try here to distinguish it from security, which is about protecting the information that you have from outside intrusion or from internal deliberate theft. And as you can probably guess, they're interdependent, right? You can't protect someone's privacy without securing their data from unauthorized external users because you have no control over what those people would do with it, and they never authorized you to do it. And on the other side of it, inadequate protection of a person's privacy can make them more vulnerable to certain kinds of security attacks. Like if you know personal details about somebody, you can theoretically use that to claim you lost your password and get access to their accounts. Notoriously, somebody did that to a journalist with regard to their Apple accounts, and he wrote an article about it. You're also more vulnerable to spear phishing, which is maybe something we ought to talk about, but I won't get distracted by it here. So privacy regulations are about ensuring that you use data only for what you collected it for, that you collect it and use it only in accordance with what the user of the data permits you to do. They may or may not get consent, but they're at least aware of what you can do and what the limitations are, and that you protect it appropriately.
So let's talk about the collection for a moment. So if I just have a website that is user consumer facing to the world, what kind of data am I likely to be collecting? Because one of the concerns I have as an investor is a lot of the companies we invest in may be collecting data and don't even realize it.
I think often people are collecting data and don't even realize it. They may not even realize some of the things they're doing with it. And given that today most websites use a lot of third parties to deliver content and infrastructure, they may not even be aware who they're sharing it with. And I think all of those points are a problem. If you're in a business where you're dealing with sensitive data about people, you're fully aware of that, right? So if you're in healthcare, you may be regulated in the US by HIPAA and in other countries by as sensitive data under the GDPR or what have you, depending. But at a minimum, all websites are in an automatic fashion collecting some data about the people who visit them. And that data ranges from the IP address they're coming in from, which is considered an identifier under GDPR, for example, even if they're dynamically assigned by the provider. You may be collecting information about their computer, about their browser version, that sort of thing. You may have code on your website that interacts with cookies and tags that individual has accumulated that can actually relay quite a bit of information. And in turn, you may be providing quite a bit of information about what they're doing on your website to those third parties like Amazon, for example, or if they have a Facebook cookie. And that may not matter much, right? If you're a large electronic sales company, what that means is they may start getting ads for whatever they looked at on your website. From a privacy perspective, they probably don't care that someone else knows that they're shopping for a USB hub. You might, because they may be telling your competitors that this guy wants a USB hub and offering him ads for it. If you're a site with health information, they may be inadvertently leaking what that person's looking at. And this is all simply in the course of an individual interacting with your website. If you're a website that actually handles health records, then they may be giving you detailed medical information in a direct interface kind of context as well.
So first of all, I've been asked to ask, what is GDPR?
I'm sorry. It's the General Data Protection Regulation passed by the European Union and affecting, for the true geopolitical nerds in the audience like you, it actually isn't just the European Union that's in scope for GDPR. It's the EEA, so that adds 3 additional countries to it. Switzerland has a similar kind of thing going on as well. The UK is leaving the EU, but they're going to harmonize regs at least for a while, right? And it's the set of regulations that control the protection of personal information of European Union persons. So you are in scope for these regulations if you are processing data about an individual that has been generated in the European Union, or if you are processing data in the European Union, even about people outside it.
So let's just take an example of like my site. So Advertise Globally, I do have members in the EU. So presumptively, I would have to comply with GDPR as well as every other state where I have a member? Or what if I said I didn't want European members? Is that sufficient to get out of it?
That can be. That's an interesting question, right? Blocking European IP addresses would be safer. Not marketing through European channels would be important. The edges of this are a little bit fuzzy. They're a little up in the air. If you really want to stay out from under GDPR, block European IP addresses. And note here, it's where the individual is accessing you from that matters in that context, not what their nationality is, right? So if you go to Stuttgart and access your website from there, that's GDPR data. That access is. Um, but if a native of France comes to Chicago and accesses a US website, her access doesn't generate GDPR coverage data. It's not about nationality.
So, I mean, there's obviously easy cases like health data, and let's come back to that in a moment. But I'm thinking about the inadvertent times when you may have to comply. So one is users access you globally, and everything today is accessible globally. A second thing is you may have third-party software which tracks information. So you've mentioned cookies, you've mentioned maybe some marketing programs. Are there other kinds of either plugins or software from third parties that could track without your knowledge?
There are. There's a significant. I mean, it's actually interesting when you dig in and you discover, and this is the kind of thing we're working on in Apamaya, and I'm not going to pitch us explicitly, but we certainly have the ability to show just how many third parties are present on your website, how the data is flowing, and in turn where it's flowing from them, because you can find third parties 4 or 5 levels down as the data travels. Pretty much if you're using a third-party analytics service, a party to manage tags, you're getting content from a third party, you're getting advertising from a third party. In all of those cases, the data flows not one way. You may be getting data from them, and that may be what you're focused on, but you're sending data to them to get it. And in fact, the European Union has woken up to this with respect to services like Google Analytics, and it is problematic because one of the things that some of these regulations have, and the GDPR does, is a localization requirement. There are restrictions on cross-border data flows. So, you know, you may be located in Lyon and you have your website and your site there, and you're on a cloud provider in Paris, so you're all within France, you're within the EU. But you're using Google Analytics, which means some of that data is getting filtered back to Google's data centers and is leaving the European Union as part of that. And you're responsible for that flow. You're responsible for what happens on your site. And it's possible that European Union court decisions will require European providers to not use those services, which may force Google into standing up a European DC under the rules, or may force other things. It's very dynamic.
So is what you need to do to comply, again, put aside health data for a moment, because that's a little bit separate. For a lot of the because a lot of the things I've seen, for example, in our companies, is it's mostly all of the advertising that is getting them caught up in this because of all the tracking. The in many cases, the CEOs of our companies.
I want to point out though that even if your business isn't the handling of personal information, you're doing it in the course of your business because you have personal information about your employees, your contractors. Some of them may be in other countries, right? Business is global, especially now when we can't physically leave our houses. And you also have information about client personnel, sales leads, prospects, points of contact for provision of service, and so forth. So even if personal information isn't explicitly your business, you're not just running into it in the form of info from people who hit your site. You're using it day to day for other aspects of your business just to run it, and you can't ignore that.
So I guess I have 2 questions. So if you have this information, what are the kinds of policies you should have? And I'll just tell you the other questions. You can do them in any order. And then from a security standpoint, what are some basic prudent practices to protect that information?
If you'd let me back up a step, because there's really a set of very basic things that you should be thinking about, and they apply just as much to a startup as an established company. In fact, if you're a startup, that's great news because you have the opportunity to get this right from the beginning, which is number one, awesome, having been in both situations, and number two, very much helps you comply with things like GDPR, which require you to design in privacy and data protection. But you have to do a set of things. First, you should have somebody on board who understands privacy to make sure you do all of this right. Know what personal information you're getting, know what you're doing with it, know who you're sharing it with, and remember that's challenging. Know what regulations apply to you, make sure you follow those. Make sure you have internal policies and procedures that reflect this. Make sure you have an external facing privacy statement or privacy policy that reflects this. That's actually a legal requirement under a number of these jurisdictions. Make sure you get consent from individuals for uses where you need it. Get rid of it when you don't need it anymore. And throughout all this, the most dangerous thing, the second most dangerous thing you can do is not have comprehensive policies. The most dangerous thing you can do is have them and not follow them. And you don't really want to be in either of those buckets, so follow them and then repeat. The problem with privacy is it's an iterative process. Things change, the regulations change, they change frequently. And right now they only move in one direction. They get more restrictive, they get more privacy protective. We've talked about the European jurisdiction. Europe has a new set of regulations on electronic communication coming that will tighten down things like Facebook Messenger, tighten down cookies. Cookies aren't long for this world, but it's not that specifically targeted, right? It'll scope in a lot of stuff. California, which already has the CCPA, which is above and beyond anything in the United States, has another set of regs coming up to be voted on in November. And if they pass, that's even more restrictive and even more GDPR-like than the CCPA, right? So it evolves. Also, when your practices change, you have to change the policies around them. If you suddenly start ingesting a type of data that you hadn't been bringing in before, that may not only require you to change your policies and procedures, it may bring you in scope of a regulation you hadn't been in scope of before. I mean, the obvious example is, oh, hey, suddenly we're doing business in Japan, so we have to worry about the Japanese privacy law. But a shift in type of data, right? We're going to start accepting our own credit card payments rather than using a third-party provider. Don't do that, by the way. Suddenly brings you in scope of the laws around credit card data and the standards like PCI DSS. If you start taking in health data under the wrong circumstances, you could bring yourself in scope of the US HIPAA law if it's health data about US people. So this is very much iterative. You have to keep looking at what you're doing, making sure you're complying, know what's coming down the road, and make sure you get ready to get there.
So a lot of the attacks on privacy that I've read about are, well, they're tightly integrated with security breaches, but a lot of them involve effectively manipulating people who are trusted inside of organizations. Is that your experience? And what as a company can you do to help prevent some of those issues?
I think,
in other words, it's not the traditional hack. It's they find someone on the inside who willingly kind of opens up the database.
So both types of attacks happen, and depending on who you talk to, one or the other is dominant, or it's about 50-50. I think actual numbers on security incidents and actual percentages are problematic because they only get reported really when they need to for some reason, meaning they fall under the scope of a law that requires reporting. You guys have all seen that some major companies held back on reporting on specific incidents and are now getting nailed for it. But certainly threats related to insiders are huge, and they come in a couple broad varieties, and it's worth mentioning this. You're talking about malicious insiders, where someone who you've trusted, who you've given access to, deliberately and with full knowledge that they're doing it, compromises data that you're holding. That does happen. Far more common is a situation where they either simply screw up and don't follow appropriate practices, or they get maliciously tricked into screwing up and not following appropriate practices. I think insider threat is huge. It's one of the reasons that I advocate more strongly than most people in the field the value of educating your staff. You have to train your people to understand what appropriate practices are, to understand what the threats are, to recognize sensitive data, and to have confidence in their ability to recognize and escalate something when they're not sure about it. That makes sense?
Yeah, and I was actually thinking more about someone who's tricked into giving a password away because someone's trying to deceive them. So that's
Sure. I mean, there are different terms we use for that, but essentially, it's a type of social engineering, and the reason social engineering works so well is first, it works brilliantly by comparison with direct technical attacks, because direct technical attacks on people who have sensitive data and know they have it are actually kind of hard, right? Strong crypto is strong. While there are gaps in any kind of security scheme, it's often harder to launch a technical attack than it is to trick humans. Humans are the weak link because we're unpredictable, because we want to help people. And the techniques that are used for tricking humans are ancient. Pretty much every religion's scripture includes at least one cautionary tale about people lying to you. And the reason for that is that's something you need to warn people about. So social engineering works very well. And it's one of the ways in which privacy threats tie into security threats, not just in the way you're thinking, which is that somebody who uses social engineering to gain access to data is obviously violating the privacy of that personal information. But little breadcrumbs about a person may not cause that person any damage on their own, but may allow a hostile individual to build up enough of a picture of that person that they can convincingly fake being a legitimate contact of theirs or a legitimate second order contact. Hey, my friend David said you were interested in, or this is your boss's boss, I'm so-and-so VP of engineering, and thus communicate with them either by telephone or via email in a way that tricks them into believing they're talking to a real person they can trust, and then they'll give up information they shouldn't give. So even relatively not information that's not relatively sensitive on its face can, if aggregated, become extremely dangerous in the hands of a social engineer. And it can become extremely dangerous on a large automated scale in the hands of somebody who's doing phishing. Phishing, of course, is sending email messages to people in order to trick them into either giving you information or clicking on a link or performing some action, which then will compromise them further, like typing in their password. And we all process electronic mail in such an automated fashion in our heads because of the amount of it that we get, that it's very easy to trick somebody into an instinctive response to an email if you know enough to make that email believable. And where you go from that is really sort of the bad guy's option, right? It can be anything from gaining a piece of information about the person that you're going to use down the road to do it again to somebody else, but better, to inserting malware on their desktop that then allows your technical colleagues to perform a technical intrusion of their network space and move laterally and grab what they really want. That's called an advanced persistent threat. We probably don't want to dive down into that too deeply, but that's how the RSA compromise started. Spear phishing emails were sent to a number of individuals who didn't have especially sensitive access, but they were at least within the network. Some of them fell for it. That's how the Anthem attack happened and so forth.
So take a quick break for just a second. A number of people have joined midway. So if you missed the introduction, I just want to let you know that please feel free to ask questions. The two easy ways to do that are at the bottom of your screen. We have chat, and we also have a feature for questions. I will see both, and I want to make sure we get everyone's questions in. One question I do have, Joe, is if we could talk a little bit more about health-specific data. We have a number of people on the webinar who are in health-related fields where they have medical information, in some cases genetic information, in some cases specific patient records. So what are some of the high-level things those companies should be thinking about?
Sure. Do you know what jurisdictions they're in?
Uh, I know one is based in the United States, but does a lot of work in Asia. The other questioner I don't know, so I don't.
Sure. So first thing to keep in mind about health data is that anywhere where you have privacy regulations, it will be scoped into them. And where you have baseline privacy protection, it will be considered sensitive. So it'll be above and beyond the basic protections. Probably a good thing to mention here. The US is unusual in how it deals with privacy. In the US, we deal with privacy by data sector. And historically, we usually only deal with it after there's been a highly publicized problem, right? Why do we have a law that protects video rental records? Because of attempted Justice Bork's Supreme Court confirmation hearings where somebody pulled up his video rentals. They weren't very interesting, but it did kind of point up, hey, people can go get this, right? We had laws already that protected library data, what books you've checked out, but we hadn't extended it to video. Now we have. The healthcare protection laws came about because of some highly publicized situations where employers got hold of their employees' health history and took adverse employment actions against them. There's a genetically linked condition called Huntington's. It's horrible. If one of your parents had it, you have a 50% chance of having it. The prognosis is not good. And a railroad company that funded its own health insurance for the non-US people, that's another thing that's weird about the US, decided to get employees' genetic records and find out who had people with Huntington's in the family and then fire them so that they didn't eventually come down with it on the company's insurance program. Some other things like that happened. So when we got a law about automating the processing of health insurance claims, which is what HIPAA is originally about, and the portability of health insurance, we also got provisions about protecting that data in electronic form. So within the US, data about an individual's health that has, simplifying, touched a covered entity at some point, a healthcare provider, payer, clearinghouse, is regulated by HIPAA, and it's very strictly regulated at the federal level. States can have stricter laws, and some do, but they can't have more lenient ones. It is possible to hold health information and not come under HIPAA. For example, if the only health information you have was provided directly to you by a patient, and you're not functioning as a health provider or anything of that sort, or a processor on behalf of one, then that won't be covered. For example, if someone goes on to WebMD and looks up mesothelioma, the fact that they looked at that page is not protected by HIPAA because WebMD is not a covered entity and the individual can disclose that. In Europe, as in other places, which are mostly modeled on Europe, in Europe, privacy is protected across the board. And the historical reason for that was the use of individually identifiable information by the Nazis during and before World War II. And so in Europe, the default is everything's protected. Some stuff is protected more than others. Some things you can use without consent, but they're still protected, and that's all in GDPR. Whereas in the US, the default is it's not protected unless it falls into one of these categories by business sector or type of data where it is. So in Europe, everything is protected that's personal information, but health data falls into the sensitive category, which means you're not allowed to process it at all unless you meet a fairly narrow set of criteria. Many other nations that created their regulations after the GDPR or before the GDPR rolled out, but after its predecessor, the Data Protection Directive, are modeling on Europe. Nobody's modeling on the US.
So in terms of policies that you put in place for other than say, for example, health data or some specifically regulated data like financial information with credit cards, in most cases, is having a sufficiently stringent set of policies you actually follow going to be enough to get you through the minefield?
Well, I mean, those policies carry restrictions, and actually following them isn't as simple as just saying that, right? Actually following them is going to involve only collecting the data you need, getting rid of it when you don't need it anymore, sometimes getting consent from individuals for the use of their data, sometimes not, depending on what the use is. And that's true pretty much across the board, right? There are things you can do without consent because it's inherent to the process. Like if somebody contacts you about buying something, you're allowed to process the data you need in order to do that transaction. And also making sure, okay, you're allowed to have the data in this context, but that doesn't mean you can use it for other things necessarily, or it may mean you can use it for other things, but you have to get permission first, right? So you're regulated not only in what you're allowed to collect, and to some extent how you're allowed to collect it, but also what you're allowed to do with it, and who you're allowed to disclose it onto. It gets much more complicated if you have someone processing it on your behalf. You're then responsible for their actions, and so are they. If you process HIPAA-covered data, PHI, on behalf of a hospital, you suddenly become what HIPAA calls a business associate. There are contracts you sign acknowledging that you're a business associate. But as far as the feds are concerned, you became one as soon as you started handling that data, and you're under the rules. If you didn't know that, that's an unpleasant surprise because you're almost certainly out of compliance with it. So yeah, you have to set up policies and procedures that are consonant with what's required for the data. I'd say really the first step is understand what data you're getting, and who you're getting it from, and what you're allowed to use it for, and what regulations that scopes you into. It's hard to give a simple answer to any of this because it's all sort of an interconnected web of policy and processes and regulation and good practice.
So if you have an existing business, are there audits that people perform to sort of say, where are we today? This is opposed to setting up from scratch in the beginning where you can design it any way you want. But if
Right.
I have an existing business with data, how does one go about even conducting an audit?
You get a knowledgeable person. It can be somebody who's already knowledgeable about what your business works out of your compliance function, or an outsider that you bring in. And you honestly, given the breadth and specificity of some of these regs, you sort of start from ground zero and make sure you really know what you think you know. Do a data inventory. If you don't have a data inventory, you should have one. I'm not going to qualify that statement. If you don't know all the data you have, you need to. You can do data flow diagrams to better understand how and where that data moves. It's helpful. And then you need to look at what you're doing. Are you doing things with the data you don't need to be doing? Are you retaining data you don't need to have? Are you getting rid of it on a schedule? And sort of work from the ground up. Understand your structure, what you have, what you're doing with it, who controls it, and look at your policies and procedures. Look at your public-facing policy first because everybody can. Therefore, that's more likely to get you in external trouble than your internal ones will because people don't see them. And make sure, identify the regs you need to be compliant with, identify the best practices you want to follow. I'd like to say, and I certainly would say in the case of a startup, have basic principles that guide your company. Take an ethical and moral stance about protecting the privacy of users. You may not really be required to do this, but you should. and it future proofs you because your regulatory obligations are getting tighter and tighter as time goes on, right? Understand that it's your job to protect the people you have information about. That may go and above and beyond what the current regulations are. Um, and the current regulations don't really completely reflect all the ways that we ingest and use data these days. But work from ground up, figure out what your principles are, figure out what requirements you have to meet, and then really understand what data you're getting, what you're doing with it, where it's going, and adjust your practices and policy to meet where they need to be. You know, the best time to do this was when you started, establish these processes, but the second best time to do it is tomorrow, right?
Well, in the next few hours.
Sure, yeah.
So is there an option to store some data in anonymized formats, or where it's partially obscured, or is that
Yeah,
really?
and it's a good one, right? I mean, this goes to, I've already said kind of, if you don't need it, don't have it. Um, but sometimes you need the data in aggregate form, or you need the data, but you don't necessarily need to be able to link it to specific individuals. And it's sort of the next level drill down of that. In those contexts, get rid of the identifiers and keep the data if you can, right? I mean, you may need permission to do it depending on the regs you're under. But yes, you can. It's a challenge because in some contexts, the date on which an event occurred can be an identifier. For example, under the US HIPAA regulations, but you do kind of need to know relative time. Um, you'll hear three different terms. De-identification is largely now a term of art used with respect to the HIPAA regulations. Again, dealing with US individual healthcare data, HIPAA does have some specifics about how they expect you to do this. And there's an easy way that's not as protective and really wrecks the data for a lot of analytic uses. And there's a harder way where you really need a specialist biostatistician to work on it with you. When you get into the GDPR territory, there are two levels of data that are worth talking about here. One is pseudonymized, where you do have the ability to connect the data back to a real individual, a specific identifiable person, but it's not present. You can give a data set to people in a state where they can't, because there's a lookup table that you have somewhere else and you give to them, right? So you substitute something for the name, or you substitute something for a social insurance number, and the person who receives the data set and is using it can't tell that's David Frazee, but you have the ability to go back to a lookup table internally and, for example, add more data to David Frazee as you get it. The second method is called anonymization, and anonymized data cannot be tracked back to an individual. And you have a lot more freedom in what you do with anonymized data. And honestly, pseudonymization, anonymization, de-identification, David, we ought to think about whether it's worth doing a talk on that at some point, because it's a very complicated drill down, but that's the basics of what these terms mean. And anonymized data will in fact take you out of GDPR scope because it's no longer personal information. It's just a bit of a challenge to get there, especially since GDPR isn't too specific about what you have to do to accomplish it.
So we have a slew of questions here. I don't know if I should hit you with the hard one or the easier ones, but I'll just do the order they were asked. So
Sure.
First question is, someone has a number of people under 18 who use their website, and some as young as middle school age. Are there any special privacy rules they should be aware of?
Yes, pretty much everywhere. 18 is probably not the cutoff. It may be the legal cutoff for consent to data collection in some cases, but the cutoff varies. And in the US, you have to look at COPPA, wow, I got myself into trying to say an acronym that I haven't had to use in years. It's about the protection of children's online data on websites. And it's why you'll find websites that say you can only use this site if you're over 13 or with parental consent. GDPR also has specific provisions on child data, as does CCPA, and the cutoffs vary. It may be 16 or 15 or 13, depending on where you are.
So
But
here's
often, yeah, you do have to worry about that.
Next question is, my company runs medical trials for FDA compliance. Are there any special privacy laws we need to be aware of?
Yes. And I didn't mention this because it's a bit of a drill down. The FDA has its own regulations on clinical trial data. You may or may not also be in scope for HIPAA if you're doing this within the US. You may or may not also, because I come from healthcare, so I'm capable of getting really nerdy about this, but this isn't really the setting for it. You may or may not be in scope for HIPAA just because you're involved with clinical trials, but you might. In the EU, this is health data. It's subject to GDPR, and in other countries, it may or may not fall under their privacy laws under a similar rubric.
So,
but in all cases, though, where health data is covered by a law, it's considered sensitive.
So the next question is, this user says that her website has received requests from people to destroy all data the website maintains about particular individuals. Is that something a website owner has to do?
Again, depends on jurisdiction. GDPR has the right to be forgotten, and that extends not only to you, but to downhill organizations you've given the data to. There are exemptions from it where you don't have to destroy the data, including where it's necessary for continuing operations or retaining just enough of it so that if they give you a request never to contact them again, you're allowed to have a list of people you're not allowed to contact again, right? Otherwise, you'll keep doing it potentially. CCPA has similar provisions. HIPAA has some provisions like that don't operate exactly that way. So often, if you get a request from someone to destroy the data you hold about them, you have to do it. Whether you actually have to in this specific case or not is dependent on the specifics of the situation.
Okay, next question is, I have a number of my employees working from home during COVID. Am I still allowed to track what they do when they're working from home using their personal computers the way I am if they're in the office?
In the US, probably. In the European Union, probably not.
Does it depend on the software they're using or if they're logged into?
It depends on a lot of things, right? You absolutely are allowed to track what they do on the company intranet and the company email. In the US, you could probably get away with putting a more general tracker on someone's personal machine with their consent. In the European Union, I'm not at all sure that you could. And in some countries, you wouldn't just be bumping up against the GDPR, you'd be bumping up against labor law. For example, in Germany, in that context, don't just worry about the GDPR, worry about the works councils. They're going to be even more trouble on that. So that's of all the questions I've gotten on this, that's the one that would scare me the most to give inappropriate legal advice on. It's very situation specific.
Yeah, I'll do it for you, but for people who watch the Demystifying Silicon Valley courses, I constantly say your facts are always specific, get individualized legal advice. This is general education, so don't rely upon this to guide your individual decisions.
Right, and I mean, it's still a very reasonable question though, right? So if I look at that question as being, is this something I need to worry about? The answer is yes. You do. You're right in your belief that that's potentially dangerous under privacy regulations. And I'm warning you that it's also potentially dangerous under labor laws in Europe. Also, if you're monitoring their computer, you may inadvertently eavesdrop on data that's protected in other ways. For example, in the US, if you're catching information somehow that relates to them getting medical care, because everybody's doing that by telehealth now, right? you may be doing something you don't want to be doing there.
So next question is, you mentioned spear phishing early on, but never said what it is.
I apologize. So let's first talk about what phishing is. And it's spelled with a PH like the band, right? And phishing is sending emails to people in an attempt to get them to do something they shouldn't do, like directly give you information or download a file or click on a link in the email, right? Generally, phishing emails are blasted out in an immense quantity to a large group of potential people, only a small number of whom will actually be valid marks. And by the way, that's why people still do the Nigerian prince scam, because the early stage of it where you just blast a lot of email out is super cheap. And you want to weed out anybody who's going to become more difficult in the later labor intensive stages. So you really want people who are totally naive and would actually respond. Basic phishing is kind of like that. Super simple, blasted out to a lot of people. You don't necessarily know much about them. You may know a little. Spear phishing is when you target your phishing message to the recipient in some way. So if you get a message from your boss's boss at your work email address from her work email address, and it says, please have a look at this file and tell me what you think. Bob is out of the office. You're very likely to open that. And that file may itself contain malware that then infects your computer. That email was spear phishing. I'm an American Express card member. If I get an email that appears to be from American Express, which is easy to do, right? First, you get a copy of a real American Express email. Then you steal all the graphic collateral from it. Then you compose something with the same layout and you kick it to somebody who you know is a card member. Chances are good they're going to just click on it. I don't. I'm professionally paranoid, but some phishing emails are very good. Spear phishing means that they have specific information about the recipient they're using to target that email to one person. An email to a whole bunch of people you know are American Express card holders may or may not fit the definition of spear phishing, but it's certainly more targeted than general phishing. An email that specifically references people you know or a hobby that you have. Hey, I know you like Ultimate Frisbee. We're putting together, and they got the information that you like Ultimate Frisbee from your LinkedIn account, or your Facebook wasn't protected the way you said it was, or they buy large quantities of marketing data about people who like Ultimate Frisbee, whatever. It leaks out there in a lot of ways. So spear phishing is mail sent to target a specific person. Spear phishing attacks should scare you. General phishing attacks, they may not know anything about you. Spear phishing, they do, which implies that they want something specifically from you that they think they can get.
So I'm going to do a last call for questions because we're coming up on time limit here. So while people put in their last questions, these are the things I wrote down as Joe's advice. So tell me if I get any of this wrong or if I'm missing things. Know what information you're getting. Know what you do with that information. Know who you are sharing it with. Know what regulations apply. Make sure you follow the regulations. Make sure policies and procedures reflect this both internally and externally. Have a correct privacy statement and policy. Follow it. Make sure you get consent from individuals who are required to use their data. Get rid of data when you don't need it. And just to repeat, follow everything in your policies and the law. And have someone who's responsible for all this, I think you said as well. What am I missing?
The main thing you're missing, I'll pick a couple other things, but the main thing you're missing and that people really need to understand is this is never a one and done. This is an iterative process. You don't just set this up and we're great, we're going to go forward, that's awesome. The legal environment changes too rapidly. What data you're getting may change, and who you're getting it from may change. All of those things may change the obligations you have. And sort of my second point on this is make sure you really do know who all you're giving it to and who you're sharing it with, because with the increasing presence of third parties for core website operations, my bet is you don't. Or even if you think you do, you don't know who they're sharing it with. And that can create not only problems for your users, but potentially exposure under different regulations as well. And that also evolves over time and changes in ways that are invisible to you. And again, this is a problem that's very interesting to me, and it's a problem that we're working on at Apamaya. But the basic point is, be aware of this, be aware of these exposures, be aware that this is constantly a moving target, and that you're never done.
So we have two last questions
Sure.
from the same person. So let me just ask them together, and you can handle them in any order. So one is, how should technologists think about designing their products to remain compliant with contemporary guidelines and laws? And the related question is, how far can you get using common sense legal compliance as opposed to working with a lawyer?
Sure. Design your products with privacy and security as part of the requirements from day one. Privacy by design, security by design are both, I mean, they're very general concepts, but there's a lot written about them out there. And they're explicitly required, for example, under GDPR. So design with the idea that you're only going to collect the data that you need to collect, that by default, your settings are privacy protective. By default, you don't collect information that you don't want to have. You don't keep it around longer than you have to have it. You don't keep more of it than you need, right? If all you need is to store anonymized data, do that. If you need more than that, then storing it in pseudonymized form and separating the key somewhere is a good protective practice. Follow best security practices generally. Don't be casual about this. And in the context of a talk to people who are working on startups, I can't stress this enough. There are a lot of things that you may be tempted to hand wave until you're up and running. Don't hand wave this, because it is exponentially more expensive to build in good security or privacy to your processes later than it is to think about it and do it from the beginning. This isn't just a philosophy. This is very much true. From a security perspective, storing personal data encrypted is important. From a privacy protection perspective, that's important in the sense that unauthorized people can't get at it. But often legally encrypted data is still actually the data from a privacy point of view. So simply encrypting it doesn't get you out from under those obligations. Then the second question is, do you need an attorney? You need at least the ability to consult with one. You may not have an internal privacy counsel, especially early on, but you need to be able to get one. Does the person who does privacy for your organization day to day have to be an attorney? No, not necessarily. And many aren't. But it can help. However, again, if you have somebody who solidly understands privacy and compliance, and there are professional certifications for this that give you some idea that they at least know the standard stuff. I've got a couple professional certs. They're important. They're not the whole story, right? Because they're kind of a minimum standard of knowledge, but their presence can give you a bit of confidence that they've at least been exposed to this stuff. So I do recommend them. Generally, you will need access to somebody who can actually interpret regulations, who can vet your legal statements, like a privacy notice and a privacy statement. Those are legal statements. Who can ensure that the correct privacy provisions are present in your contracts, both up and down. Because if you have obligations, you have to pass them to your vendors. And you're responsible for what your vendors do if they're getting the data. So you want ironclad contractual clauses. Some stuff like GDPR data transfer outside the GDPR area requires contractual language in some fashion. The one option that didn't require contractual language as such still required certain statements in your privacy notice, and that's Privacy Shield. And Privacy Shield has currently fallen to a European Union court decision. The other options require contractual language. So does your head of privacy have to be an attorney? No, but you need to at least give them access to one who knows privacy.
So we have all sorts of questions piled up, but we're up on our hour. So for those who are members of Demystifying Silicon Valley, Joe is also a member of the site, and feel free to continue this discussion there. For those who are not members of Demystifying Silicon Valley, I hope you've enjoyed this hour, and I encourage you to come check the site out. We talk about these kinds of things all the time and how to build a startup from conception all the way through exit. But I do need to call it a wrap because we're up on our hour. This video will be made available on the Demystifying Silicon Valley website. I'll create a link for it so it's a public document if you'd like to have access to it, and we'll upload it in various other social places as well. Thank all of you for spending your Wednesday morning US time with us. I know we have people from all over the world. Any further questions, feel free to reach out to me or to Joe, and we would love to get you the information you need. Joe, thank you for taking the time to do this.
Well, and thank you all for attending, and please feel free to follow up if you'd like to talk more about any of this. And
I will tell you, Joe, there are a number of questions about Privacy Shield that what you said just triggered, but we'll do those offline. Okay. Thank you, everyone.
No problem.
All right, bye.
Bye.